On April 3, 2025, a surprising report emerged from the European Union. The EU, the birthplace of the world's most famous privacy law, the General Data Protection Regulation, or the GDPR, is planning to cut it down. The GDPR was supposed to protect your data, but now it's seen as expensive, confusing, and maybe even bad for business. 7 years in, the GDPR is still giving companies a headache. A 2025 report found that 75% of German companies still struggle to comply. 1/3 of apps disappeared from Google Play Store after the GDPR kicked in. And Oxford economists say that it has shrunk business profits by over 8%. So now, Europe wants to fix the GDPR, streamline it. Across the globe, India has rolled out its own privacy law, the Digital Personal Data Protection Act 2023, or the DPDPA. The DPDPA is India's first full-fledged privacy law, and the goal? To protect your personal data without copying Europe's mistakes. But here's the twist. India's law might be even more burdensome than the GDPR. First, it fails to include a key ground for processing personal data, legitimate interest. Broadly, legitimate interest lets companies process individuals' personal data for activities like fraud prevention, cybersecurity, and marketing without bothering individuals for permission every time. This ground exists not only under the EU GDPR, but also under other global data protection laws, like that of Singapore and Brazil. Earlier drafts of India's data protection law also contained a similar provision, allowing companies to process personal data for reasonable purposes like network and information security and fraud prevention without consent. But the DPDPA deviates from these earlier drafts and does away with the concept of legitimate interest altogether. So now, for every notification, every offer, every security update, companies need to ask for your consent. Welcome to consent fatigue. You get tired, stop reading, and start opting out of everything just to avoid the noise. But that noise comes at a cost. Weakened security, more spam, and less fraud prevention. The DPDPA also ignores something called contractual necessity. Imagine this. A wants to send a gift to B. A uses a logistics company, but B never gave consent to that company. So what happens next? This is where contractual necessity comes in. This ground for processing personal data allows companies to carry out processing without consent if this is necessary for the performance of a contract. This ground exists not only under the EU GDPR, but also under the data protection laws of countries like China, Singapore, and Brazil. What happens when contractual necessity is not a part of data protection laws? In the scenario described earlier, the company cannot legally deliver the gift to B because it doesn't have her consent. But it can't even call B to ask for consent because that too would be illegal data processing. Now extend this problem to logistics, e-commerce, BPOs, and apps. Anytime a service involves someone who didn't click agree, the system breaks down. No consent, no service. Ironically, India set out to build a smarter, leaner law than Europe's. But without grounds like legitimate interest and contractual necessity to enable personal data processing, the DPDPA might end up being even more impractical than the GDPR ever was. Too much reliance on consent risks overwhelming users, paralyzing businesses, and undermining the very idea of privacy. Here's what India should do. It needs to amend the law to add both legitimate interest and contractual necessity as legal grounds to process personal data, akin to other global data protection laws. Doing so would simplify compliance so that protecting privacy doesn't mean stopping everything else. Because a good data privacy law should protect users without wrecking the digital economy. This is the SCI Center. If you found this explainer useful, like, share, and tell us. Is India creating a privacy safeguard or building the world's biggest digital roadblock?